a gang rape of a 6-year-old child is pending for 12 years in the court, that itself is appalling. It cannot be. The petitioner complainant is before the court seeking to summon seeking to summon the magistrate for examination or for the veracity of the statement made by the victim under section 164 of the CRPC. That having been declined, the petitioner is before the court. Facts adumbrated are as follows. A crime comes to be registered in crime number 155 of 2014 for offences punishable under section 376 and section 4 and 6 of the POCSO Act 2000. None of your rights will be affected because of that. 2 years in the sumne pending. That's not correct.
If I may just make my submission, my lord.
Oh, please, on what, madam?
My lord, I understand the concern expressed in the morning.
Don't worry about the concern. What's your contention?
My submission is that only in very narrow and exceptional circumstances can a magistrate be summoned. Extremely narrow,
I will write
my lord.
when. Not for corroboration. Only when the victim who has made a statement, particularly in sexual offences of a minor, only when the victim who has made a statement wriggles out of that statement, then the prosecution will have to prove it by getting the magistrate. Not otherwise. It's not a routine thing that magistrate will be summoned and the statement that is recorded will be put to test.
No, I'm in complete agreement with my lord's statement that it's not a routine aspect. The only issue, my lord, is that I will be deprived of the corroboration.
No, you will be deprived of nothing, I'll tell you. Wait. Just wait.
It may work against me in the
No, it's not against you at all. Yes.
Judgment, my lord.
You just hear it and then yes. The petitioner.
One Supreme Court judgment on the
point. Whatever you have, give it. Paragraph.
In paragraph 30, my lord.
30.
30. Yes. On page 11 of the judgment.
Yes.
On the second part of in the bottom part of the paragraph where it says, furthermore, the concerned magistrate could have been examined as a witness in the present matter to clear the controversy on this aspect, and for unexplained reasons, he was never called for examination, especially when a completely hostile version was being provided by the witnesses to the proceedings.
I'll answer. There won't be an order against you. Yes. Because I'm also aware of the sensitivity in the matter. A gang rape of a 6-year-old child is pending for 12 years in the court. That itself is appalling. It cannot be. Yes. We'll dispose the whole hog now. The petitioner. Who are you?
My lord, the de facto complainant.
The petitioner complainant is before the court calling in question an order of the concerned court hyphen the special court dated 20th February 2024 by which the concerned court declines to allow the application of the petitioner seeking calling of application of the petitioner and filed under section 311 of the CRPC seeking to summon.
There was no application, my lord. The PP made a request.
All right. Seeking to summon seeking to summon the magistrate for examination or for the veracity of the statement made by the victim under section 164 of the CRPC. That having been declined, the petitioner is before the court. Heard, what's your name?
Spurti Kota.
Heard the learned counsel Spurti appearing for the petitioner and the learned HCGP for the respondent. Facts adumbrated are as follows. A crime comes to be registered in crime number 155 of 2014 for offences punishable under section 376 and section 4 and 6 of the POCSO Act 2012. The fulcrum of the crime was a gang rape of a 6-year-old child. The police then conduct investigation and file a charge sheet drawing accused number 1 and 2 for the offences under section 376 of the IPC and 376 and 202 of the IPC and section 4 and 6 of the POCSO Act, as well as section 21 and 21(1) and 21(2) of the Act. During the course of the recording of evidence of the victim child, it is during the course of the examination of the victim child, her statement was recorded under 164 of the CRPC by the special judge. Trial advances. The prosecution files an application before the concerned court. Application la memo.
An oral submission.
The prosecution makes an oral submission before the concerned court that the magistrate should be summoned for examination with regard to the statement recorded under section 164 of the CRPC. That is declined in terms of the order dated 20th February 2024. Therefore, the trial, the crime that happened in 2014, an order is passed on 20th February 2024. This is what is called in question in the case at hand. The coordinate bench of this court grants stay of the further proceedings before the concerned court, and the stay is still operating in the case at hand. The case now is 12 years old. The learned counsel for the petitioner Spurti, taking this court through the statement or the law or the provisions of the act, would submit that calling of the examination of the magistrate in the case at hand is imperative for twin reasons. One, corroboration of the statement. Two, there is no sign of the victim after recording of the statement under 164. Therefore, tomorrow, if the statement recorded under 164 is not given credence, the entire case of the prosecution would tumble down and the accused would walk away with an acquittal. It is therefore the learned counsel submits that submits that the examination of the magistrate in the aforesaid twin circumstance is imperative, and the concerned court erred in not permitting the magistrate to be examined in the case at hand. Per contra, the learned HCGP would refute the submission in contending that the magistrate who recorded the statement under section 164 of the CRPC cannot be summoned for examination in a routine manner. That is, the
magistrate signature was also not present, ma'am.
The learned HCGP would further, taking this court through the records, would submit that the magistrate has already recorded that the victim's signature had recorded that the victim's signature and victim and the magistrate's signature was missing. Therefore, in those circumstances, the magistrate who recorded the statement and did not affix his signature, in those circumstances, the petitioner is before the court that the magistrate who recorded the statement, who did not affix the signature of the victim or his, is necessary to be brought in for evidence to be proved. I have given my anxious consideration to the submissions made by the respective learned counsel. The afore narrated facts at this juncture would lie in a narrow compass. What drives the petitioner victim de facto complainant to this court is the permission not being granted to summon the magistrate for recording of evidence. The circumstance is twinfold. One is that the victim's signature is not found and the magistrate's signature who recorded the statement is not found. It is the apprehension of the prosecution. Recording of the statement of the child is dealt with under section 24, 25 and 26 of the POCSO Act. It reads as follows. Nowhere the statute mandates that when a statement of the child under the POCSO Act is recorded, the signature of the child should be obtained, as the child that is victim of sexual abuse, age of the child of the victim of sexual abuse could vary from 3 to 18 or 2 to 8 in given circumstances. Therefore, the statute does not mandate signature of the victim child on the statement recorded. The other issue is with regard to the non-signature of the learned magistrate. When a learned magistrate who recorded the statement under 164 can be called to depose with regard to the statement recorded is in elaboration dealt with by the division bench of the Madras High Court in 2017 SEC Online Madras 38316, where an identical circumstance the division bench of the High Court of Madras observes as follows: page 6 to 20, para 6 to 25, 50, 51 and 81. The division bench of the Madras High Court lays down certain guidelines as to when the magistrate could be summoned for giving evidence on a 164 statement recorded by him in the capacity of being a magistrate. Those circumstances are not the one that has warranted summoning. A oral submission is made before the learned magistrate, before the special court, that the learned magistrate's signature is not affixed. Therefore, the magistrate should be called in for examination. This would run completely counter to what the division bench has held, Madras High Court has held, to which I am in respectful agreement of. The apprehension of the learned counsel for the petitioner that the statement would not be given any credence is only an apprehension without rationale. The stage of not giving credence would not arrive, or has not arisen. In the event during the trial, if the statement of the victim is sought to statement of the victim rendered before the learned magistrate is sought to be denied, the victim denies the statement, or the accused would make use of the fact that the signature of the victim or the signature of the magistrate is not affixed. It is then the petitioner, perhaps the complainant, perhaps could be aggrieved by the inaction of not getting the magistrate. The stage is yet to arrive. Even then, law does not require a child's testimony given under section 164 of the CRPC to be signed. Insofar as the magistrate is concerned, even that is not a requirement in law in terms of the recording of evidence as necessary under section 24, 25, and 26 of the POCSO Act. The other submission is with regard to speedy trial. It is not in dispute that the crime is registered in the year 2014. It is shocking as to how the concerned court has gone on granting adjournments for over 10 years till the matter reached this court on a particular issue. It is surprising that the concerned court, in a case of gang rape of a minor child of 6 years, has dragged the proceedings for 10 long years. Reason may be manifold. The court ought to have been vigilant of repeated adjournments or indiscriminate grant of adjournments in a case of gang rape. Right to speedy trial involving sexual offences is the right of every victim who has suffered such a blow the sexual abuse. The Apex Court in 2025 SEC Online SC page 2066 has, following the judgment of the Apex Court, following the earlier judgment in Khatun, Hussain area Khatun, has held as follows, para 12 to 31. The Apex Court holds, particularly in sexual offences, the mandate of the statute must be followed in letter and spirit. The POCSO Act, the Act clearly holds that the proceedings must conclude within 1 year